All right. Still on ownership. The owner of property has the right to enclose his property with a fence, a wall, or any other means. There is a very beautiful case in this connection. I referred to Custodio versus Court of Appeals. There was a property owned by a person. There was no fence around this property. So, some of his neighbors were passing through his land to reach the public road. Later on, the property owner decided to enclose his property with a fence. Consequently, his neighbors could no longer pass through his land. They had to take a more roundabout route to reach the public street. They filed a complaint for damages. The court said, this is a case of damnum absque injuria. The property owner was simply exercising a right explicitly granted to him by law, the right to enclose his property with a fence. If in the meantime, great inconvenience was caused to his neighbors who now had to take a longer route to reach the street, it's just too bad. But they obviously do not have the legal right to claim damages. Please take note that when the case was decided, there was no easement yet. Wala pang easement. Okay? It was only after the case was decided that the court said an easement should be created, but they should pay indemnity. So, as long as there is no easement yet, you have the perfect right to enclose your property with a fence. That's very clear in Article 430 of the Civil Code. A property owner, of course, has the ius utendi, the right to use his property. But the right to use one's property must be exercised in such a way as not to injure others. Sic uteret tuum utalienum non laedas. So use your own as not to injure others. In one case, there were two adjoining properties. The owner of the higher property built their own certain artificial, bodies of water. There were artificial lakes, there were water pots, etc. Unfortunately, during inclement or bad weather, some of these constructions were washed away and they fell to the adjoining lower estate. The court, the lower court dismissed the case. The Supreme Court said the case should be reinstated, applying Article 431. While you have the right to use your property, you should use it in such a way as not to injure others. Obviously, the court considered the construction of these artificial bodies of water, artificial lakes, etc., on the higher estate as something which causes, during bad weather, some damage or prejudice to the adjoining lower estate. You also take note of the provisions of Article 432 of the Civil Code. Sometimes referred to as the emergency doctrine, emergency rule. If you are the owner of a thing, the law says you have no right to prohibit the interference of another person with your property as long as the interference is necessary to prevent an imminent danger and as long as the threatened damage or injury is greater, is much greater, as a matter of fact, the law says, much greater than the damage which would arise to you from the interference with your property. In this connection, the view has been advanced, to which I agree, that negligence on the part of the person interfering does not preclude resort to the rule under Article 432. If, for example, while I was using my car, another vehicle owned and driven by Mr. X careened into the street, and well, it was being driven recklessly, slammed into a Meralco post and started to billow with smoke. It was obviously on fire. Under this article, Mr. X, although he was negligent in driving his car, would have the right to interfere with my property. If I happen to have a fire extinguisher, for example, I do not have the right to prohibit his interference with the use of that fire extinguisher. His negligence does not preclude him from invoking the rule under Article 432. Obviously, any possible damage which might be caused to me through the use of my fire extinguisher is much less than the damage which would result to the complete burning of his car. So, in that case, I submit the requirements of Article 432 would clearly be met. You just read Articles 43 and 434, okay? Actual possession under claim of ownership raises a disputable presumption of ownership. The true owner must resort to judicial process if he wants to recover his property. And then the requirement that in an action to recover property, the property must be, number one, identified, and the plaintiff must rely upon the strength of his own evidence and not on the weakness of the defendant's claim, which is in accord with the rule that he who alleges has the burden of proof. Okay? Article 435, on the other hand, is simply a restatement of the basic principle in constitutional law. One of the inherent powers of the state is, of course, the power of eminent domain. Property may be taken for public use as long as there is payment of just compensation. Article 436, on the other hand, is a restatement of the rule on police power. Of course, the moment the state, the government exercises its police power, then property rights must necessarily yield. Okay? And if property is taken or damaged or destroyed as a consequence of the exercise of police power, of course, there is no right to any indemnity. The only indemnity you get, the only possible indemnity you get is the feeling, okay, of satisfaction that somehow you have contributed to the common good. All right. I call your attention to Article 437 at this point. The owner of property is the owner not only of its surface, but of everything under it. If you are the owner of a parcel of land, you own not only the surface, but everything under it. Of course, that does not necessarily mean that that provision, everything under it, is to be taken in its literal sense. If there are, for example, minerals under your land, that does not belong to you. Okay? That belongs to our kabalikat sa kaunlaran, the state. Regalian doctrine. All right. The question is, up to what depth will you be considered the owner of what is beneath your land? Does that extend up to the middle of the earth? Okay. The rule of thumb is it extends only up to such depth as you can still make use of it. Up to such depth that you can still make use of it. And in a case decided by the Supreme Court, it would seem that it is quite deep, at least from the point of view of the Supreme Court. I refer to NPC versus Ibrahim, for example. Here was a property owner. Unknown to him, the NPC had constructed a tunnel, okay, passing beneath his land. Because this happened somewhere in Mindanao. The NPC was drawing water from Agus River, if I remember correctly. One of the big rivers there. So the property owner was not aware that there was a tunnel underneath his land constructed by the NPC. It was only much later when he